amendment to a division should make that clear in debate. Clause 4, Amendment 11, Baroness Hamway.
My Lords, at the last stage of this bill and very late in the debate on this amendment, which was then in the name of the Noble Lord, Lord Flight, I'm glad that he's able to be here this evening. Having listened to the Minister, I asked what she would advise a couple, one British, one an EU national, living in the EU, who both have elderly parents, on one side of the family in the UK, on the other in that EU country. They are, faced with not just the end of free movement, but an impossible choice. Not just where they should live after March 2022, but which parents they should decide to care for personally. Having to make that decision within the next 18 months, 15 months after the end of the transition. The Minister herself had an impossible task in responding to my question as to whether picking between parents was a humane response. She argued that people will have had and will have plenty of time, but does that really address the point? Since the committee stage, I have had so many emails, as no doubt have other noble lords, making clear how many different family situations there are, all presenting families with similarly impossible choices. And I'd like to thank everyone who has written to me and to other noble lords. They've taken such care to contact us, not with standard formulaic emails, but very powerful descriptions of their situations, their concern, their distress. Noble lords will understand that I want to read some of them into the record, and they'll also understand that I can't read all of them. But as examples, a lady of 75 living in the Netherlands supporting a Dutch companion and vice versa, whose mother is 96 in a care home in the Netherlands. A lady of 79 in the UK who expected to receive support, part-time care from her daughter, who would be prepared to give it, provided her French husband is able to move to Britain. A couple in France with a 12-year-old son faced also with whether to uproot him from school. A family in Italy, one parent British, one Italian, with two teenagers of dual nationality, one of whom has just started at university in the UK, and the other who may want to make her life in the UK. And the parents may want one day to follow their daughters. And so it went on. We're a global society, and families come in all shapes and sizes and places. Many people make the point that their residence outside the UK makes them feel no less British, and that they're surprised to find themselves writing as they do. Many say that the prospect of separation from family is unbearable. All say that when they moved abroad, they had no idea that there could be restrictions or conditions on returning as a family. And my lords, the amendment provides, and I find it, that the regulations must make provision to enable UK citizens falling within the personal scope of the agreements referred to return to the UK accompanied by or be joined in the UK by close family members without conditions on the entry or residence of those family members, which could not have been imposed under EU law relating to free movement on the day on which the Act comes into force. I've been asked about a detail of the amendment, the reference to close family members. As it happens, in a select committee yesterday, the Immigration Minister discussing family reunion used exactly that phrase. But I suppose the technical answer is that these provisions would be implemented by regulations which would be precise, but by anyone's definition. Partners and parents where the relation subsisted, which in the case of parents obviously it would, at the end of the year and continues would fall within it, as well as children. The Minister explained in the context of various amendments at committee that the government was seeking not to be discriminatory, or perhaps seeking to be not discriminatory, but to end discrimination between, on the one hand, EEA and Swiss citizens, and on the other hand, other citizens. But the government's proposals for ending the current arrangements in March 2022 would discriminate between those families of mixed nationality who happened to have settled in the UK and those who settled elsewhere in the EU. They would require Britons who wish to return to meet conditions for sponsoring a spouse and children. The financial requirements, the minimum income requirements, are not easy nor by any means available to everyone. 40% of UK workers could not reach the minimum income requirement, and the non-British partner's income can only be taken into account after 6 months, assuming he or she can get here in the first place. If you want to bring elderly parents, they have to be so much in need of care that, and this was evidence given to a working party that I chaired some years ago, so much in need of care that they probably would be unfit to travel. If you yourself are older and no longer earning, can you reach the income threshold? This would be discrimination against our own citizens, imposed retrospectively on citizens who had no expectation that this choice might lie ahead. Lifting the end date would not mean unlimited numbers of people coming here with their families. As I have explained, we'd be talking about people who fall within the agreement, their families, children, and others with whom the relationship subsisted before January 2020. I asked rhetorically at the committee stage if this was really humane, and I ask now if it's the right approach. To ask that, I think, would also be rhetorical. Since committee, I have begun to realise just how inhumane, and so I will give notice now, I suppose it's notice for Monday, that barring assurances which I can't say I anticipate, though they would be very welcome, but I will put the matter to a vote in accordance with the procedure which we are now having to give notice of. For the purposes of the debate this evening, I beg to move.
Amendment proposed, page 3, line 8, at end insert the words as printed on the Marshall list. The Earl of Clancarty.
My Lords, I have added my name to Amendment 11 in the name of the Noble Baroness Lady Hamwee. When I spoke to this at committee stage, I genuinely thought that this was something that the government had overlooked, but discovered that this is not the case and that there is some history behind the government's position. The reason perhaps for my naivety is that the argument as I saw it, and as I still see it, is very simple. It would be wrong to put a deadline on British citizens returning to the UK with their families. It would be deeply unfair to do so, and I'm glad that the Noble Baroness Hamwee intends to take this to a vote if their government do not accept this amendment. My Lords, the Noble Baroness Lady Williams, the Minister, at committee stage cited the case which the Conservative government of the day brought against Surinder Singh in 1992, and said at the beginning of her reply that the amendment, and I quote, refers to a specific cohort of people relating to what is known as the Surinder Singh route for family immigration. My Lords, this statement, I'm afraid, betrays an element of cynicism in government thinking about this issue, and of course I do not blame the Noble Baroness for this. But this is an inappropriate analogy in the sense that the government clearly has not accepted the decision made in Surinder Singh's favour, and it is an inappropriate analogy for a couple of reasons. One of them is that there is a universal cut-off point which applies to both British and European families, which of course is the end of this year. We will not then be part of the EU, and there will be a limit on the number of families, both European and British, who might then come to this country from Europe. The second thing to say is that we are talking about many British citizens who have been married for many years, often to other European partners, though it should not matter where in the world their partners have come from. And they are often building families with strong and complex roots in the UK and the rest of Europe. They have done so believing at the time that they had a settled life in Europe, wherever that may be in Europe. That was their bona fide position. Yes, people get divorced and indeed married for all kinds of reasons. That is life. But this government is applying the government of 1992's perception of that case to generalise about all British families living in Europe. British citizens and their families in Europe are not that cohort as the government perceives it, and it is insulting to all British families currently living in Europe that they should draw that analogy. My Lords, as the Minister might imagine, it is clear that amongst British citizens and their families abroad, the concerns are widespread. I will quote one example to add to the number that the Noble Baroness Hamway has given. A British woman I have spoken to, in a relationship with an Italian citizen since before the referendum, and now married with a 2-year-old boy, has a father in the UK. Her husband is tied to his job in Italy, and it is simply impractical for them as a family, perhaps not for another 10 years, to make the move which she thinks she may have to make at some stage to look after her father in the UK in years to come. But leaving it beyond March 2022 would become a bureaucratic nightmare which risks splitting up the family for several years, even if income criteria are eventually met. And as we have already heard, this is by no means a lone case. My Lords, it is worth saying that over 50 veterans from across the armed forces who live abroad have signed a letter in support of this amendment, a letter coordinated by British and Europe, and some peers may have already received this. Of course, they will know from having been in the armed forces abroad precisely what these concerns will entail, and indeed may have younger family members in this position too. As they say in their letter, and I quote, "Why should service personnel or anyone who is British be discriminated against in this way?" My Lords, the government's position on this seems so unnecessary and unfair, also in consideration of the fact that EU citizens who have settled status will correctly have lifetime rights to have existing spouses join them in the UK. My Lords, this is a question of fairness and humanity, and I hope that the government will relent.
Baroness Bennett of Manor Castle.
My Lords, I was pleased to attach my name to this amendment in the name of the Noble Lady Baroness Hamway, but very sorry after the powerful debate that we had in committee that it was still necessary to put this down again. Back in our debate report stage on Amendment 6, the Noble Lady Baroness Smith of Newnham referred to the long and continuing discussion the Noble Lady the Minister and Baroness Lister of Buttersert and many others, including myself, had in committee about the many amendments that we sought to have applied to all affected by immigration law, the ruling out of scope of those amendments, and the claims from the Minister that what we were tabling was subsequently discriminatory. That's an argument, however, that cannot, or certainly should not, be applied to this particular amendment, for the situation of Britons married or partnered with Europeans is particular. It can only be said particularly awful. I would say that no one with a non-EU spousal partner could have predicted the onerous and unjustified minimum income requirement applied in 2012. Those are not my adjectives, but those of a High Court judge. But what I would say would be an unreasonably harsh assessment might say, well, they should have known that the rules could change when they made their family arrangements. Yet the many Britons who've been writing to me, and as the Noble Lady Baroness Hamway said, no doubt many other members of your Lordship's House, who established families in Europe in many cases decades ago, could not conceivably have imagined that the dreadful state of British politics over the past 5 years that's brought us to the current pass. I join the noble Lady Baroness Hamway in thanking all of them for taking the time, having the courage to share their circumstances with us in the hope that we can get the government to listen. But rather than make my own arguments, I'm going to, as close as possible, let Jane, a Briton who gave me permission to share her story, speak for herself in your Lordship's house. Jane says, I'm a British citizen resident in Italy since 1993 with my Italian husband and children. I have my widowed mother, aged 76, living alone in the UK. She is fortunately in good health at the present time. However, one must be realistic. In time, she may need extra care. As her only child, I have always reassured my mother with my husband that we would be there to care for her in her later years. But due to the possible outcome of this bill, we are increasingly worried. Like many other Britons who moved to the EU while Britain was a member, I had and expected to keep an almost unfettered right of return to the UK with my family. My mother and I were safe in the knowledge that I could always come back should the need arise. I do not want my mother to have this worry. I would like her to grow old, knowing that we can come back to the UK should that need arise. Unless this bill is amended, this right will be removed on March 29, 2022, creating impossible choices for me and thousands of families like mine. The government's answer is that we are given 15 months from the end of transition to return with our families to the UK. This is ignoring the massive practical difficulties of uprooting ourselves from family life and work in our country of residence. I have my own business here in Italy, not to mention my husband's work and our children's education. And there may be no need to do that uprooting. That's the end of Jane's words. I would like to ask the noble lady the Minister if she will personally respond to Jane, tell her what the government's justification is for putting Jane and her family in this situation. The Green Group wholeheartedly offers the support to Baroness Hamway if she chooses to put this to the vote. Thank you, my lords.
Baroness Lister of Burterset.
My Lords, I was prompted to speak in support of this amendment by an email that I received this week from British citizen, born of Britain parents, British parents in Britain. During voluntary service overseas, she met and then married an Italian and lived in Italy, working for a UN agency for 30 years. They adopted an Italian boy who has Italian nationality. Her husband died, and she was hoping in the future to return to the UK where her brother and sister live. But this would now mean her leaving her son behind, which, and I quote, which she writes, I could never do, we are very close, I could never leave him behind in one country, me in one country and he in another. She and others that she knows in a similar situation can't believe that their families will in future be split up in this way. I also wanted to refer back to what the noble lady the Minister said in committee at the end of the debate on another family reunion amendment. She appeared to be agreeing with the noble Lord Green of Deddington, his argument for raising the minimum income threshold referred to by the noble Baroness Lady Hamway earlier from 18,600 to 25,700 or even 38,000 in order to cover the cost of public services or make a net contribution to public finances. And I know these figures came from the Migration Advisory Committee, but they're premised on a very narrow understanding of what constitutes a contribution to our society, the same kind of thinking that will exclude care workers and others, other key workers from immigration, as we heard with regard to an earlier amendment. And the argument discounts the right, the importance of the right to family life. And I hope perhaps the noble lady, the Minister, might say now that actually she wasn't, that I misread what she was saying and that she wasn't supporting that suggestion that the threshold should be raised. I hope she will say that. The damaging impact of the minimum income threshold has been documented in a number of studies, most recently from the University of Bristol, and they wrote of not just the emotional impacts of separation, but financial, mental and physical hardship. My Lords, family reunion rules divide far too many families already and need reviewing. But for now, we can at least prevent even more families being split up in this cruel and heartless way. Families like the mother who emailed me and the many others who clearly have been emailing other members of your Lordship's House. But we can prevent that happening by supporting this amendment.
Lord Oates.
My Lords, my noble friend Baroness Hanway has already eloquently set out the powerful arguments for this amendment, as has the noble Lord the Earl of Clancarty, the noble Baroness Lady Bennet of Manor Castle and the noble Baroness Lady Lister of Berthaset. As my noble friend Lady Hanway has told us, at committee stage she asked the Minister how she would advise a couple, one British and one an EU national, who both have elderly parents. In which country should they choose to live? Which set of elderly parents should they pick? In response, as my noble friend reminded us, the Minister said that the government had given people plenty of time. But my Lords, that's not an answer. It doesn't matter how much time they've had. They could have had all the time in the world. It doesn't change the fact that the government is forcing them to make an invidious choice, to make it by 2022 and to live with it ever after. If they need to stay in the EU member state of the EU national to look after his or her parents, after 2022, they will no longer be eligible to return to the UK together. So I ask the Minister once again, how should that family make their choice? I would like her to provide an answer to that essential question, which she failed to give to my noble friend, because it goes to the heart of the issues and the terrible choices that will be inflicted on our citizens and their families as a result of the government's policy. My Lords, the government has made much of taking back control. Well, this is a test for ministers of what that control will mean in practice. Will they act with compassion or with cold-hearted indifference, and in doing so inflict intolerable injustice on thousands of families of our citizens? I'm sure I'm not alone, and we've heard testimony from previous speakers in having been contacted by numerous British citizens with heart-rending stories of the misery that the government's present policy will cause to them and to their loved ones. People who settled as British citizens in the EU and who made their lives there with their partners, who now, through no fault of their own, are facing their future plans being torn up by ministerial obduracy and callousness. One such example is Fiona, who lives in Luxembourg with Miguel, her German-Chilean husband. He studied his O and A levels in the UK, where his father was a professor. He later took a job as a translator in Luxembourg, where Fiona joined him. They've now been married 25 years and have lived in Luxembourg all that time. They always assumed they would be able to return together to the UK, as Miguel was an EU citizen. And they made their life plans on that reasonable assumption. Now, through no fault of their own, unless they return before 2022, Fiona would only be able to do so alone. Her two children could, in theory, come with her as their dual nationals. But if this is the way the UK intends to treat their German father, they have no wish to do so. And I can't say I blame them. Fiona says, as a British citizen, I feel exiled from my country of birth and the rest of my UK family. My Lords, that's the reality of the government's position, to de facto exile British citizens from the land of their birth. The only argument I've heard ministers advance to justify the injustice they are about to inflict is that somehow maintaining the existing position wouldn't be fair on British citizens living outside the EU who are married to non-UK nationals. But my Lords, this is the hollowest of empty arguments. British citizens moving to live in an EU member state had the reasonable expectation that they would be able to return to the UK with their partner at any point. The gross injustice that is being done lies in the fact that existing rights are being stripped away. My lords, if the government does not move on this policy, British citizens are going to face a very stark choice come 2022. They will either have to return alone without their wife or husband or other family members, or not at all. That is the reality. So I hope that all members of the House will be clear when they eventually get to vote on this amendment, that they won't be voting on some abstract piece of policy. They will be deciding the future of thousands of British citizens and their families. They'll be deciding whether those families have to pick which elderly parent they will stay to care for or which life plans they have to tear up. Above all, they'll be deciding whether to lift a massive burden of anxiety from the shoulders of our citizens in the EU or to impose a further weight of misery upon them. Even at this late stage, it remains in the government's hands to show by accepting this amendment that it has a human face. But if it does not, I hope it will be resoundingly defeated when the virtual lobbies are functioning once again.
Care of Kinlochard.
I'd like to congratulate the Minister on her stamina and the courtesy in enduring what were a lot of second reading speeches earlier in this debate. I wonder if, like me, she misses the Countess of Mar, who's very good at intervening at report stage to criticize those making second reading speeches. This grouping, this debate is rather different, and I sympathize with the Minister for a different reason, because I think she has a very difficult task in answering Lady Hamway's question, repeated again tonight. I do think that the oddity of this debate is that we are seeking to avoid discrimination against UK citizens. The EU citizen here now, or coming here by the end of this year, has quite rightly the right to keep or bring in family members. But from 2022, the UK citizen living abroad, where he went or she went exercising legitimate expectations, is having that right withdrawn. I agree with everything the Noble Lord Oates has just said. I find it hard to understand the response the Minister made to the Noble Lady Hamway's question last time. I am particularly puzzled by the catch-22 that from 22 the accompanying partner will have to satisfy the minimum income requirement. But how will the returning partner be able to demonstrate the 6-month history of earning in order to satisfy the requirement? It seems to me to be a really rather vicious catch-22. I do think that the core of the matter, though, is the extraordinary callousness of requiring our people, our citizens living abroad, to make these difficult choices that are spelt out in our email inbox these days. Whether to break up the family or to favor looking after the dependent relative in the country of residence, somewhere in the 27, or to look after, to come back to look after the dependent relative in this country. These are the only 3 options that are available. And it really is extraordinary that we should be putting our citizens who exercised their legitimate expectations and expected to lose none of their rights, and were told that they would lose none of their rights when they chose to marry and live somewhere in the 27 or the 15 or the 12, whatever it was at the time. I do think we need a proper answer to Lady Hamway's question. And if we don't get one, and I feel sorry for the minister, because I don't think she's going to be able to answer satisfactorily, then I certainly will be voting for this amendment.
Next speaker, Lord Judd.
My Lords, Lord Oates was absolutely right. Do we or do we not want to be a society based upon compassion and concern, or do we want to become a nation without a beating heart on humanitarian issues of this kind? As far as the European Union is concerned, there is, of course, a special challenge, because citizenship means citizenship going right back to classical times. And we took away what people in good faith had come to understand as their citizenship and the rights that followed from this, and went to make lives and futures and careers overseas. But they never dreamt that they were breaking links with their home base. Many of them wanted at one point to return. And of course, as we've heard from one speaker after another, many have families rooted here for which they feel responsible and want to feel able freely at a time of crisis to be able to return and succor the needs of such people. My Lords, I think it's altogether good news that the Noble Lady Baroness Hamway has moved this amendment. It represents the kind of Britain in which I want to live in terms of the values that are behind it. Do we believe that families are fundamentally important? The psychological, mental health more generally, the physical health, to the well-being of citizens. Do families, or do they not, provide a unit of stability in the midst of an increasingly complex and demanding and unpredictable world? What are we doing with this bill? It is almost impossible to understand how the government has got itself into this position. My Lords, I hope we stand very firm behind the Noble Lady this evening, or whenever it is we're allowed to put the vote on this matter.
Thank you. Baroness Smith of Newnham.
My Lords, I rise to support the amendment in the name of my noble friend Baroness Hamway. Probably that comes as no surprise to noble lords. And I'm going to do something that I normally try not to do, and that's to rehearse one of the arguments that has been going on for years, because for 5 of the 6 years that I have been a member of your Lordship's House, we have been talking about having a referendum on leaving the European Union, having the referendum, and then trying to deal with the fallout of the referendum. And the debates that we were having in October 2015 have been rehearsed again and again and again. I've tried not to rehearse them. I recognise the UK voted to leave and that we have left, and that at the end of the transition period, things will be different. But one of the points that was made during the EU referendum bill of 2015, in the debates then, was the importance of enfranchising EU nationals resident in the United Kingdom, but also UK nationals resident elsewhere in the European Union. And the reason that was suggested was precisely because those groups of people were disenfranchised, and yet they were going to potentially to suffer or to be more affected. I won't use the word suffer. I realise that could be seen by some as inflammatory, but they would be more clearly affected than many of the rest of us who aren't actively using our rights as EU citizens. My Lords, British citizens who have opted to use their rights under EU law to marry, to reside, to have the right to family life as EU and UK citizens shouldn't have those rights torn away from them. We've heard many individual cases this evening, but my Lords, could I just take a slightly more general approach? When an EU national is working abroad in another EU country, family members also have the right to reside and work in that country, regardless of their nationality. My Lords, that has applied to UK citizens. The idea that the Minister puts forward that somehow people have 15 months to make a make or break decision, you can come back now or stay away. You can't come back with your spouse, with your children, with your in-laws, with close family members. Is that really what people thought they were voting for? Taking back control is surely about us making the right decisions. They don't have to be xenophobic, they don't have to be exclusionary, they don't have to be choices that say no to people. But in particular, why should we make it harder for British citizens who chose to live in other European countries because they were exercising their rights and living with people they loved? Why should we make it harder for them to be in the United Kingdom after March 2022 than EU citizens with settled status? My Lords, we should at least be as generous to our fellow British citizens who've used their EU rights as we are to EU citizens who are going to benefit from settled status. Please can the Minister talk to her colleagues in the Home Office and get the government to think again?
Lord Flight, who will be followed by Lord Dubbs.
My Lords, I would hope that the government has already seen what course of action it should take. I can see absolutely no sensible reason for the proposals being as they are, and I might perhaps add, apart from the issue of acting in a civilised way towards individuals, I can't believe that many people or that much costs are involved. And so I can't really understand why the government has so far stuck on this issue. I think, as we know, the purpose of the amendment is to preserve the right of UK nationals living in the EEA and Switzerland who return to live in the UK in future to bring with them or to be joined by non-British family members on the same terms as they are at present. Unless this bill is amended, British citizens who moved to the EU, the EEA, while the UK was a member, will lose their right to return to their country of birth with a non-British partner or children unless they can meet financial conditions beyond the reach of many. If they need to return to look after their elderly parent, thousands will now have to choose between either returning alone, leaving their family behind, or abandoning their parents to stay with their non-British family in the EEA. Nobody should have to face a choice like that. The problem is that the government is using the end of free movement to make these British citizens meet for the first time the minimum income requirement for family reunion. The MIR has been roundly criticised, both because the level is so high that 40% of UK workers would not be able to reach it, and because of the catch-22 rule that the non-British partner's income can only be taken into account if they have been working in the UK for 6 months. But how do they get into the UK if they cannot satisfy the MIR? The MIR itself is harsh, but what makes it doubly unfair to apply it to this group of British citizens is that the change is in effect retrospective. When they left their homes in the UK to move to the EU or the EA, they were safe in the knowledge that if they established a family while abroad, they could be able to bring them back to England or Britain. And the British parents, when they left behind, had the same expectations. It also leads to the perverse result that the British government's approach involves discrimination against its own citizens. While British citizens who moved or move to the EA before the end of 2020 face these restrictions, EU citizens who moved or who move to the UK before the end of 2020 will not. They will have the right under the withdrawal agreement to bring existing family members here for life, as well as keeping their existing rights to return to their country of birth with families they have made in the UK. The government's answer is that they have given us 15 months from the end of transition to return with families to the UK, even ignoring the massive practical difficulties of uprooting adults from work and children from school at a time when there may be no need to do so. As Baroness Hamway put it so well in committee, I simply asked the Minister what she would advise a couple, one British and one EU national, who both have elderly parents. She is suggesting that they should pick between them for the future care by the end of 2022. Is this a humane approach? My Lords, I would just add that I believe we should welcome warmly refugees fleeing from vicious regimes who want to come to the UK and often put their lives at risk to be here. Many of them are highly skilled and they will, in time, and their families make huge contributions to this country. I would like to see us be helpful and welcome them. I detect quite often nowadays the approach is rather more aggressive. Let us be civilised.
Thank you. I call the next speaker, Lord Dubbs.
Very grateful to the Minister, who, as always, makes herself available and is happy to give us briefings and have chats about impending legislation. And I had quite a long chat with the Minister the other day about this bill and about this particular amendment. And I can't help feeling the government is making an enormous mistake. You know, this is not the way to treat people. This is not the way to behave. Now, we were told that 15 months, people have got 15 months so they can sort themselves out. But the bill, this proposal, is taking away a basic right. And taking away a basic right, whether you've got 15 months to accept it or longer, it's still taking away a basic right. And that surely is unacceptable. As the Noble Lord Flight just said, this is retrospective legislation. Nobody knew at the time. This is something that's been invented subsequently. Not a single person in this position. And I've had masses of emails, as we all have, with these terribly sad stories of people who are bewildered and agonized as to what to do. These people had no idea this was going to happen to them. None of us did. I'm sure until recently. I'm sure for a year or two after the referendum, we had no idea this would be the case. when I met the minister, or had a chat with her and her officials, one of the arguments put, and I don't think I'm out of order in putting the argument, as she's bound to put it herself later on, one of the arguments put was that we would be having two sorts of British people. Say we had a British person married to an American, compared to a British person married to a French person. And the British person married to an American would not have the right that we're arguing for on behalf of the British person living with an EU partner. But of course, no British person who married an American ever thought they'd have that right. But we're taking away the right from people who are who've expected to have it all along. And as the Noble Lord Flight also said, this discriminates against British people. How does it do that? It discriminates against them because an EU citizen living in Britain with a British partner has every right to go back to the EU country and come backwards and forwards with no constraint of the sort that we're seeking to impose on British people. So we've got retrospective legislation. We're discriminating against British people, which is surely outrageous, and the arguments don't stand up. I honestly believe the government should back off. This is a big, big, big mistake.
Call the next speaker, Lord Rosser.
My Lords, I won't go through and repeat all the arguments in favour of this amendment, which have been so eloquently put by so many noble lords. I agree wholeheartedly with what has been said. All I want to do is to read from one of the emails that I have received. It says, I'm a British citizen, born and bred in England, who currently lives in France with my Dutch partner and our 12-year-old son. My ageing parents still live in the UK, and it is not beyond the bounds of possibility that at some point in the future I would like to return to live in the UK, principally to be closer to my parents and help look after them in the autumn of their years. I was horrified to learn that as things currently stand, from 2022, I would face a means test in order to return to the UK with my family. A means test to return to the country of my birth, of which I am a fully fledged citizen. I'm sure that you can appreciate what an absurd situation this is. Like all other British citizens who moved to the EU while Britain was a member, I had and expected to keep a right to return to the UK with my family. At the time I left the UK, my parents were safe in the knowledge that I could always come back should the need arise. Many of us met a non-UK partner while in the EU and made a family with them, believing that our family would remain united wherever we lived. Unless this bill is amended, our right to return home with our families will be removed from March the 29th, 2022, leading to impossible choices for me and thousands of families like mine. This would be a completely inhumane situation. And a further one received, and I just read the last sentence of that one. It simply says, unless this bill is amended, the right of UK citizens to live in their own country with the partners of their choice will be negated and for no obvious benefit to anyone. Is this an humane or necessary approach? No doubt that is a question the government will answer in their reply, but I'll say now that if this amendment is put to a vote, we will be supporting it.
Minister. Minister Williams.